We are set here today on a final trial for the division of property.
Jennifer, would you state your name for the record, please?
Jennifer Parks.
Okay, and you are one of the spouses in this divorce, correct?
Correct.
Okay, and as the judge said, we're really just talking about the value of the home, and we don't have much time, so we're going to do it really, really quickly. What is your understanding of the value of your marital home?
It's about $113,000.
Okay, and what do you base that belief on?
We've gotten a most recent cash offer appraisal, including the repairs that need to be done to the house. We've also had an appraisal done several years ago that also cited the condition and the repairs needed that falls. Yeah.
Okay, we're going to break that down just a little bit. So did you have a professional appraisal done that you paid to have done on December 16th of 2023?
Yes.
Okay, and did that appraisal come back with an estimated value of the home at $165,000?
Yes.
Okay, and did that appraisal also list some repairs with costs, including HVAC, plumbing, foundation, clean out, paint, floor repairs, and upgraded appliances?
Yes.
Okay, and did those repairs estimate come out to $134,484?
Roughly, yes.
Okay, and that appraisal is part of the documents that you provided to me to support your inventory and appraisement that now is before the judge, correct?
Right. Yes.
Okay, and for the record, that's part of P7, the zip file. Okay, so have you made any of those repairs that were listed by the appraiser?
Yes.
Okay, and which of those repairs have you done?
I have replaced the HVAC system and the appliances in the kitchen and in the laundry room.
Okay, and now the HVAC, did you finance that?
Yes, and my mother co-signed it.
And your mother co-signed it. So that's the Carol Bennett, I think was her name.
Correct.
Okay. And the sheet about the loan and the lien that's on the home is also included in that inventory and appraisement document set, correct?
Yes.
Okay, perfect. And you've been making payments on that HVAC?
Correct.
Awesome. Did Catherine help you pay for any of those repairs that you just mentioned?
No.
Okay. And then did you more recently get an open door offer in December of 2025?
Yes.
And was that cash offer roughly $113,000?
Yes.
Okay, and we've included that open door offer also in our paperwork, correct?
Yes.
Okay. Generally, is the housing market in your area better or worse for sellers now than it was in December of 2023, in your opinion?
I think, in my opinion, it is much worse.
Object, Judge, on this one to speculation, and if she's testifying as an expert, then I'd like to take her on void dire about her retail experience.
All right.
Not intended to be an expert.
Okay, sustain unless there's personal knowledge.
Okay. Perfect, Judge. Jennifer, have you been paying attention to the housing market in your area over the past several months?
Yes.
And how have you been doing that?
I've been looking on the MLS listings. I've been looking at all of the houses that have for sale signs as I drive through my neighborhood and have remained with for sale signs for the last year in my neighborhood as I drive through.
Okay. And have you also looked at online real estate websites like Zillow and things of that nature?
Zillow, Redfin, MLS.com. Yes.
And based on those things, do you have an understanding of, kind of not an expert opinion, but just kind of a layman's understanding of the general health of the housing market in your area?
Yes, I do see that a fully flipped and renovated house is no longer going for the same price now as it was 3 years ago.
Okay, that's sufficient. Are your children, the children of the marriage, living with you primarily in the home?
Yes.
How long have those children lived in that specific house?
13 years.
Okay. What work would be required to get the house market ready in your layman's opinion?
The foundation to be repaired, and the plumbing, the underlying plumbing for at least half the house. It needs new flooring, definitely, for it to be sellable.
Okay.
Paint, clean out. There's a lot of excess inventory and items. A lot of that belonging to Mary from her family's items.
Okay.
So there's a lot of work. It's doable work, but it's a lot.
Okay. And roughly, what do you think the costs would be up front to get the house market ready?
It's about between 65 and 80,000 for
Okay.
the foundation and the flooring. I've had multiple estimates on flooring, which range anywhere from 10 to 20,000, depending on materials and everything else.
Okay. If you were to, instead of trying to get it truly market ready, but instead sell it on the what they call the investor market, so in other words, somebody would buy it as is and then make all of those repairs, what would you have to do to get the house ready to even just move out?
We would have to do the clean out, which involves getting a dumpster. The price for the city is $600 per month, and each load haul out is another $200. So that would be about either 800 or 1,000 just for the dumpster alone. I work a full-time job, so I would probably need to hire somebody to help me do some of this because the kids can't carry that much furniture and some of the heavier stuff. So probably another $1,500.
And about how much time do you think you would need to move out of the house?
Several weeks at least for the physical aspect, but to find a place that is large enough for everybody would take probably months.
Okay.
There's not a lot of houses that are in my price range that
Okay.
would also keep us in the school district, which the kids have been in for their whole academic career.
Okay. If you, so you mentioned there's not a lot of houses in your price range in the area. Is there a place that you would prefer to move if you absolutely had to move? You couldn't keep the house. Is there a place that you would rather move rather than staying in your area?
We'd rather move to another state, Illinois, which has better.
Okay. That's good. Illinois. Now, under the current mediated settlement agreement regarding your possession of the children, are you permitted to move to Illinois?
Not at this time.
Okay. So would you ask the judge that if you were required to sell the house and move, that she make sure that the geographic restriction is such that you would be able to move to
I'm
Illinois?
gonna have to object to that, Judge. It's beyond the requested relief. It's not the issues that were before the court today.
Sustain.
Jennifer, if you were required to pay basically a buyout for Mary Catherine's equity in the home, would you be able to make and willing and able to make monthly payments toward that amount?
I believe so. I would have to know the amount to be able to give a very firm yes.
Okay. But if that
would-
was an option, would that be your preference over having to sell the house?
Yes.
Okay. And then I want to talk briefly about when did Mary Catherine leave the home, roughly, just month, year?
April 2023.
Okay, so almost exactly 3 years ago. And during that time, have you had the sole responsibility of keeping the house maintained and things like
Yes.
that?
Correct.
Okay, and has Mary Catherine supported that financially in any way?
No.
Have you expended time, energy, and money to maintain and, in fact, improve the value of the home?
Yes.
And do you believe that, in light of that fact, you should get an increased share of the division of the estate?
Yes.
Are we asking the judge for 60% of that estate for that purpose?
Yes.
Okay. And then there's some credit card debt that you disclosed in the inventory and appraisement. And is it your testimony that that debt was accumulated during the marriage and for the benefit of the community?
Yes.
Okay. And have you been paying that debt over this time that the marriage has been, the divorce has been pending?
Yes.
Okay. And has Mary Catherine supported financially the repayment of any of that debt?
No.
Okay. And do you have other debt that's yours that you didn't include because it was not supporting the community?
Yes.
Okay. And are you asking the judge to, as a part of the division of the estate, make an offset of the home value based on the debt that you've been paying?
Yes.
Okay. And as an alternative, if the judge were to decide to just have you keep paying the debt on your own without any help from Mary Catherine, but you also get to keep the house, is that your preference?
Yes.
Okay. And then did you hire me to support you in this divorce?
Yes.
Okay. And you've paid me some, but not all of the money that I've earned on this case. Is that correct?
Correct.
Okay. And do you believe that my services were necessary for protecting your interest in this divorce?
Yes.
Okay. And do you believe that my fees are reasonable for the work that I've been doing?
Yes.
Those are all of my questions, Your Honor.
All right. Attorney Devno?
Thank you, Judge. Ms. Parks, real briefly, you mentioned that you included a number of debts in your inventory and appraisement, correct?
Yes.
And they're solely in your name.
There are some, yes.
And there are other debts you're now saying that there is an addition to the ones in the inventory and appraisement, but you did not include?
Correct.
Okay, so this is not a full and complete picture of your debts that we put in the inventory and appraisement.
So, correct.
That's correct?
Yes.
Okay. In the inventory and appraisement, we had to provide supporting documentation, right?
Yes.
And you provided that supporting documentation in your P7, correct?
Yes.
And that's all the supporting documentation you provided?
So the supporting documentation that I've provided also does include those accounts, but it is not on the inventory and appraisement
Okay,
list.
but in P7, the zip provided to the court today, none of the debts and the inventory and appraisement are listed. Correct?
Your
I'm
Honor,
sorry.
I believe this is beyond the knowledge of my client. She wasn't with me whenever I submitted the P7. Those are documents that she provided to me. But I will stipulate that I don't believe that the debt statements are there. My client did not, she sent me her credit report, but it was after I'd already submitted the documents to opposing counsel. And so I didn't, I suppose I need to supplement, but I didn't have time to do that between the time that I received it and the time of trial.
Okay.
Judge, I'm not attempting to take a shot at Miss Howard. She's a great lawyer, but I think she's doing her best, but I have not, still do not have any documents supporting the debt. And they're now alleging there's $45,000 in debt that we've never seen.
Okay. The
And
court, the court hears the testimony and will give it the appropriate weight.
Thank you, Judge.
You're welcome.
Ms. Parks. Jennifer.
Yes.
We're still talking.
May I make a request?
No. This is cross-examination right now. We can't, this is not your time to make a request, okay? Your attorney can help you make a request in a moment. Right now, you have to answer my questions, all right?
Okay, the only request was to be addressed by
Ma'am,
Jennifer.
objection to the,
Okay, I believe she's making a request. I'm sorry. I believe Jennifer is making a request to be addressed as Jennifer.
oh, I'm sorry.
Because it's a little confusing because there's two Miss Parks, so
Understood. That's fine. Judge, do you mind if I use her first name?
Not at all. And thank you for asking that question. So is it okay if I refer to Mrs. Parks as Mary?
Yes, Judge.
Okay. All right. You may proceed.
Thank you. And the appraisal you had done, what was the proposed, what was the value of the home in the appraisal that you had done 3 years ago?
168,000, I do believe.
Okay, and you're saying the new offer is lower, but it's a cash only offer, correct, through open
Correct.
door?
Yes,
Is it fair to say the parties can't agree on the value of the home?
correct.
And you're not opposed to selling it?
I am not, it is not my ideal situation. I don't want to sell.
Okay. Judge, I'll pass the witness for now. I'll save my time.
All right. Counsel, Attorney Debnam, you have 11 minutes and 56 seconds. Attorney Howard, you have 2 minutes and 53 seconds.
Thank you, Your Honor.
You're welcome.
Judge, I just have one follow-up question, if I may.
Sure, go ahead.
Jennifer, regarding the debts, did you also disclose those debts in your first inventory and appraisement in this case back in 2023?
Yes,
Okay. And the new inventory and appraisement will just show the kind of the difference between how it was and how it is now, correct?
correct.
Okay. And do you recall whenever we submitted that first inventory and appraisement, did you provide the supporting documents in terms of credit card statements and things like that?
Yes, itemized statements I provided several years worth.
Okay. Thank you. That's all I have, Your Honor.
All right. You may call your next witness.
Petitioner rest, Judge.
Okay. Attorney Debnam?
Thank you, Judge. May I open briefly?
Sure, go ahead.
Judge, it's an odd case. It's primarily just assets. I think the biggest issue this case has is a disagreement about the value of the home. And I don't think any party here actually has a clear value what the home is really worth. There is an appraisement done from years ago, which is significantly less than Redfin as well as Zillow or any others recommends what the values of the home's for. They say it's 240. There may be property increases or property fixes that need to be done that are going to affect the value of the home. I'm not disputing that. My client does not know that because we've not been in the home for 3 years. I'm not trying to say that Mary is lying or Jennifer is lying about it one way or the other, but I think there's a clear confusion about the actual value of the home, and there's a disagreement to the tune of potentially $130,000. The estimates are as high as 240, as low as 110. My problem with Jennifer's recommendation is she's asking the court to accept the bottom floor value of the home and then allow her to keep it and pay my client off with that expectation rather than testing the market. So it kind of keeps the windfall on both directions for her. She wants to keep the home, but she also wants the court to accept that the bottom possible value of the home, which is the cash out value of Open Door, and then give her a payment plan to pay my client out. I don't think the court could do that. So what we're asking is to force the sale of the home and split up what is just and right from there in a 50-50 manner. I am unclear on the rest of Jennifer's requests, and I still am. It sounds like they want some reimbursements, but reimbursements aren't pled for in this case. I understand they have some debts that are related to the home, for example, the HVAC that may be tied to the home and may need to come out from the proceeds. But there's a lot of other debt that I'm really not clear on and we've not seen. These parties have been separated for a long time. My client's been living separately. And the idea that Jennifer's going to get a reimbursement from using community funds to enhance community property, I think is contrary to the code as well as contrary to the pleadings. My client is asking a pretty simple, straightforward thing today. Both parties can walk away like they already have with their separate estates, as well as force the sale of the home in a reasonable time, considering there's children here. I'm not asking to force the sale before the school year's over. but probably this summer. And with that, I'd like to call my first witness, call Mary.
You may proceed.
Mary, can you unmute your mic?
Yes,
Can you go ahead and confirm the date y'all were married?
it was February 13th, 2011,
And when did you two separate?
when I moved out on April 22nd, 2023.
So you've been living separately for 3 years, almost to the date.
Yes, that's correct.
Okay. And have you two had your finances separate that whole time?
Yes, we have.
Okay. Have you seen the debts that that Jennifer is alleging in the INA?
The statements have never been complete. There's missing statements and mislabeled statements, and some months so it's been incomplete. I've seen some of the debts, but I've never been able to get to see the backing of the information that supports it. It's never been
Okay.
completely.
Are you, I'm gonna go ahead and ask this question. It's kind of a fallback question from an earlier topic, but are you asking the court today to divorce you on grounds of insupportability?
Yes, sir.
And in your opinion, are you and Jennifer, is your marriage irreconcilable? You're not going to be able to reconcile the marriage.
That's correct.
Okay. And you're asking the court to make a just and right division that is basically a 50-50 split.
Yes, sir.
Are you asking the court to force the sale of the home?
Yes.
Do you think that if the court orders the sale of the home today, that you and Jennifer, either through counsel or on your own, can find a realtor that you agree on to put the home up for sale?
I believe so.
Okay. And if not, would you request that the attorneys submit a couple names to the court and let the court choose the realtor?
Yeah.
Okay. If there's any costs for the sale of the home, are you happy for those to come out of the proceeds of the home?
I'm sorry, could you repeat that?
If there's any costs that need to be incurred either by you or Jennifer to get the house ready to sell, are you fine with those costs being reimbursed or coming out of the sale of the home, the sale price? Okay. Are you, I know you've previously seen, but we've already had our exhibits admitted, R1 through 4, which includes our requested relief. Are you requesting the court to distribute the property in line with your requested relief?
Yes, I am.
And really, I want to just make it a little clear. Are you asking for the parties to just take what they have and go in their separate directions, except to force the sale of the home and split that?
That's correct. And then some of the items that have been listed that are separate property. I still have some property over at the other house,
Um,
and I've been unable to.
I can't hear you. We couldn't hear you. You'll have to repeat that entire answer. Come closer to the microphone. I think that'll help.
Earbuds
Oh, you have on earbuds
Sorry.
too.
Okay. So
Could
what
you
was-
remove the earbuds? It makes you sound a little muffled.
And Judge, I think she would, I of course don't want to get in right through instruction. I think she's jumping ahead of me to the separate assets portion. That's what I think she was answering about.
Oh, okay.
If you want me just to go ahead and address that.
No problem. We're gonna take a brief recess because she logged off. So I'm
Okay.
assuming she's gonna come back.
Okay.
Okay. 1 second.
Okay.
Attorney Debnam, did you need me to read back your last question?
Yeah, Judge, can I just go ahead and repeat it?
Oh, sure. Go ahead.
Mary, I think you were skipping ahead me with your answer, and that's probably my fault with my question, but are you asking for when it comes to the community assets, are you asking that y'all kind of keep what you have and then force the sale of the house and split the proceeds?
Yes, that's correct.
And both of you have separate assets, correct? That you had before the marriage?
Yes, that's correct.
And you have those listed on the inventory on the requested relief today, right? The proposed division of community estate for you,
Yes.
and that is R3.
Yes, that's correct.
And you're asking the court award you the separate assets that you have listed and award Jennifer the separate assets listed as well.
Yes. Yes, that's right.
And you have 3 529s for the children, correct?
That sounds
I'm sorry,
correct. Yes.
Jennifer does, and you're asking that they stay with Jennifer for the benefit of the children, correct?
Yes, that's correct.
Okay, Judge, I'll pass the witness.
All right. Attorney Howard,
How much time do I have, Judge?
2 minutes and 18 seconds. Attorney Debnam, you have 4 minutes and 54 seconds.
Thank you, Judge.
I have no questions, Your Honor.
All right. Anything further from this witness, Attorney Debnam?
No, Judge.
Okay. All right. Close.
Yes, Your Honor.
All right. You may proceed.
Thank you, Judge. As Attorney Debnam said, this is a very unusual but also simple case. Really, the main concern is the value of the home. We do request not technically reimbursement, but just consideration of the costs and burdens that Jennifer has taken on to maintain and improve the value of the home. And for that reason, we ask that she be considered for an unequal division. And, you know, the court has the knowledge to give the evidence its proper weight. The supporting documents that respondent has for the value of the home are Redfin and websites that don't take into consideration the true condition of the home because they have no way to know it. We have a professional appraisal and we have an open door offer. You know, those are much more directly related to this exact particular property and its condition. And so we would ask the judge that if you must force the sale of the home, you know, obviously that's within the code, but we would ask that you not do that because it would be a hardship on Jennifer, and instead that you determine a value of the home and give her the option to a buyout of some kind offset in the ways that we've mentioned, Judge. And that's all.
Thank you, counsel. Attorney Debnam?
Judge, to the disproportionate request, again, besides the fact that reimbursements aren't pled, what they're essentially asking for is a disproportionate share for spending money to upgrade or to maintain the residence that they were solely living in, which is pretty standard. Similarly, my client had to leave the marital home, the one that was community property that was her rights to live in, for the sake of the marriage falling apart, and she had to go pay her own way to live on her own in a house that didn't have equity. So I don't think there's any case law suggesting that you should get an equitable or a disproportionate share of the estate due to paying for the house that you are living in when there's no temporary orders or otherwise suggesting you shouldn't be paying for them. Second, to the value of the home and the estimations, again, we're all up in the air about what it means, but what the value of this home is. The appraisal is higher than what they're asking for the valuation to be. The open door policy is a cash only offer, which is notoriously much lower than the actual value. They're asking for you to find that the value is the open door value and then compensate my client based on the lowest possible option. I don't see, that's not in the code, and I don't see how that's equitable to my client. The Just and Right Division is forcing the sale of this house so we can figure out what the actual value is. The market will tell us what the value is, what it will be sold for, and let's sell it this summer and split the proceeds accordingly, equally with what the value of the home actually is. You can't have your cake and eat it too and ask the court to find a low valuation and then a buyout offer based on that low valuation when we're disputing it. That's all I have, Judge. Thank you.
Thank you. Mary or Jennifer, are either of you expecting a child at this time?
No, ma'am.
Okay.
No, I am not, Your Honor.
All right. And did I hear it correctly that the home, when it was appraised, the last time it was appraised for $165,000?
Roughly, that is correct. Yes.
And that was
With-
2 years ago?
3 years ago.
Right.
May I add clarity to that statement?
Sure.
So the caveat to that, in the appraisement, the gentleman did list that if it met the 3 criteria of having the plumbing done, the foundation done, and the HVAC, it would appraise for 165. And then he went on to list another $40,000 in repairs and cleanup to bring it up to a higher estimate. But he said that he didn't want to artificially deflate the value of the house. And so those are listed in the appraisement and the notes, like I believe the first or second page, those comments are also listed there. So it still ties in with the open door when they did come in and do an actual inspection of the house. It wasn't just a punch my address into the website to see what they say. It's somebody did actually come walk the house, look at everything, and take a look at the estimates, which have also been provided to the courts, and all of the repair statements. And that's using the lowest cost estimates from licensed professional companies to do these repairs. And the
Okay.
house isn't unlivable. It just, when we bought the house, we knew it had foundation issues. It's Texas. Everything has foundation issues.
I'm gonna have to object to this point, Judge.
My apologies.
Sustained. So, thank you for that information. Something else just popped in my head. Neither one of the attorneys asked, but I mean, while we're here for completion purposes, do you all believe it would be necessary to have language in here that talks about a receiver in the event that the home is not listed and timely? Because I know we don't want to disrupt the children in the school year. So I think getting it, bringing it up for sale, at least by the end of this month, May, won't be, or it shouldn't be too disruptive. It'll at least be after some of the STAR testing, unless they test in May. Do the children test in May too? Okay. So we might have to wait towards the end of May to actually list the home, beginning of June. Attorney Howard, Attorney Debnam, or are you wanting language in there? Not appointing a receiver off the bat, but
Judge, it would be my preference that we wait and cross that bridge if we get there. I know that receivers, they're going to take what little value is in that home away from these parties. So I would prefer not to, unless we need to come back personally.
okay.
I think that we're going to sell it, Judge. I think both these parties understand that the cost of getting a receiver would be pretty prohibitive to them and the amount they have. So I'm confident that Ms. Howard and I can make this follow an order of yours. If you say to sell the house, we will sell the house.
Perfect. Thank you. I just asked because I've been running into that issue lately where people have had to come back, and by the time they come back, I mean, houses, the prices fluctuate so much, it's not even valued at what it was. So I was just trying to think ahead.
We appreciate that, Judge.
All right, no problem. Thank you. So what I'll do is go ahead and render the parties divorced today, and I'll get you a ruling out sometime this week. If not tomorrow, it'll be sometime this week.
Thank you, Judge. I appreciate it.
You're welcome.
Judge.
Thank you all. Have a good day.
Thank you.
Thank you.
You're welcome.
Thank you, Your Honor.
You're welcome. Have a good day.
In this explosive and deeply entertaining courtroom battle, a self-represented defendant named Gary Thompson walks into Judge Simpson's courtroom armed with printed internet articles, YouTube video screenshots, and a handwritten 3-page document he calls his legal brief, all in support of his argument that the traffic stop that led to his arrest was unconstitutional because the officer did not have reasonable articulable suspicion to pull him over for a broken taillight. Gary opens confidently, citing what he describes as a landmark Supreme Court case that he clearly found on a legal blog rather than an actual legal database, before launching into a passionate explanation of his constitutional rights that mixes genuine legal concepts with completely fabricated ones in a way that makes it impossible to tell where his actual knowledge ends and his misunderstanding begins. Judge Simpson listens with remarkable patience for the first several minutes, occasionally nodding, before beginning to ask questions that systematically dismantle every argument Gary makes, pointing out that the case he cited was decided the opposite way from what he described, that reasonable articulable suspicion for a broken tail light has been upheld by every circuit court in America, and that the YouTube video he is referencing as legal authority is from a channel with 40,000 subscribers that is not affiliated with any law school or bar association. When Gary doubles down and begins explaining to the judge what the Fourth Amendment actually means, Judge Simpson finally reaches his limit, leaning forward and telling Gary in the most controlled but unmistakably firm voice that he has been a judge for over 20 years, was a constitutional law professor before that, has read the Fourth Amendment approximately 10,000 times, and does not require a YouTube education on its meaning, leaving Gary completely speechless and the entire courtroom struggling to contain their laughter.